May it please your lordship, one of the great advantages of the short adjournment is that it enables one to take stock and to think about certain points rather than doing so on one's feet. I was troubled, as any practitioner of arbitration would be, by the observations made by my Lady Justice Andrews. And I think my Lord called it the sanctity of arbitration, and Lady Justice Andrews looked at the world of international arbitration being somehow endangered. And my Lady gave an example of a Frenchman and an Italian, or Frenchman and a Spaniard, I can't remember which it was, having a car accident.
No, you've forgotten about the car accident. I simply said there was a dispute between Spain and France, or Spanish and French individuals.
Ah, yes, Spanish and French individuals. I think I probably had Boys and Chaplin in mind, which they then referred to arbitration in London, very wisely. Now, 2 points need to be made about that. Firstly, there would then be an arbitration agreement in existence, binding both parties, probably being, if they're European parties, that subscribe to the various requirements of individual national laws as to arbitration agreements, that they should be in writing and signed and on some occasions actually consented to. But the second, so we wouldn't be dealing with the conditional benefit arising between non-parties to the same agreement. Now, the second point is, I think my Lady contemplated that an award would be made, and then dissatisfied either Spanish or Italian or French or whoever, then sought redress before his or own courts. Well, firstly, absent one of the parties being a state, there would be a power in the arbitrators appointed under this express arbitration agreement to grant anti-suit relief, which could be enforced by the English court by an injunction. So, all other things being equal,
they're functus, the award's being granted.
It would be another dispute arising out of the arbitration agreement. My Lady, you can introduce as many qualifications as one likes to the factual premises that you're giving me, but if you'll forgive me, the power of arbitrators to grant anti-suit relief is well established. And also, if they are functus, then there is an award which is determinative of the cause of action, which would itself be raised in the foreign proceedings wherever they might be brought. And of course, the Frenchman would have to bring them in Spain, and the Spaniard would have to bring them in France. So, with the greatest of respect, my Lady, I think the example that you gave is, if I may say, entirely hypothetical and unrealistic, because there is a power of enjoinment, of injunction, and if necessary, court support, and there would be the cause of action would have emerged in the award.
It may be, Mr. Young, but the debate emerged from a discussion about the workability or coherence of the Court of Justice determination.
Yeah, oh, absolutely. And as to the workability, or well, let's take the coherence. I submit it is entirely coherent. That irreconcilable judgments can arise only if the court would otherwise have the power to grant such relief. That's what they say, if and only if. They say that now. That's is as clear as can be. Whether it's workable in every single case is another matter. But in the context of arbitration, we have to exclude all express arbitration agreements. We are dealing only with conditional benefit cases arising in a direct action context where there is a power of injunction, where there is no power of injunction, rather. So we are talking about a very limited number of cases, and dare I say it, after the end of the implementation period, whatever one may think about what led up to it, it can never happen again, because any Spanish judgment now being enforced in England will not be enforced under the regulation. So we are talking about a vanishingly small set of hypotheses which, in my respectful submission, will not undermine international arbitration as it is practiced in London. And I would entirely agree with my lady, Lady Justice Andrews, that London is a major international arbitration centre, attracting many international parties, many from within the EU, many from outside the EU. And the law is that the seat is established by that. And the courts of the seat have a very wide-ranging jurisdiction, including injunctive relief. So international arbitration, in inverted commas, is not going to be undermined or imperiled by the enforcement of the Spanish judgment in the present case, and indeed the honouring of the binding quality of the judgment of the Court of Justice in its entirety. But I would accept that there is theoretically always a possibility of having an irreconcilable position between an arbitration award and a judgment. I accept that. And that is, it is not because there is anything wrong with the regulation, it is because of the arbitration exception. And the arbitration exception is almost premised upon the possibility of irreconcilable results. So the existence of irreconcilable results is not a reason for throwing everything out with the bathwater. That's why you have to apply the regulation, where the regulation applies, as you have been told by the Court of Justice. They have resolved how the irreconcilables are to be reconciled. And they've also resolved the boundaries of the regulation and the arbitration exception. And they've done it in a way which I think my Lady Justice Andrews colourfully expressed it as bonkers. I would respectfully suggest it's...
That wasn't my wording. I was picking up a hypothetical description that I used earlier.
My lord, my lady.
None of it was intended to be in any way a suggestion.
My lady.
The decision was bonkers.
No, my lady.
It was shorthand, convenient shorthand, on a hypothetical basis.
I'm sorry. That was. I just rather enjoyed the word. It may be bonkers. I come with no brief to say differently.
Well, you say it's irrelevant.
I say it's irrelevant.
The decision is the decision, and whatever it means and whatever its bounds, you say it's binding on us, and that's really the short and the long of the whole thing, isn't it?
Yes, you're absolutely right, my lady. And I have been trying, I hope, to quell your ladyship's concerns about the threat posed to international arbitration practiced in London, because there is none. And indeed, when one looks at the arbitrations, they are governed by the New York Convention when it comes to enforcement. And that was one reason, of course, why the arbitration exception remained in existence in the various manifestations of the convention, then the regulation, then the recast regulation. So it's my submission that there is going to be no earthquake with international arbitration. It may be that there is a different, how shall I say, national interest in protecting London-based international P&I clubs if it is otherwise appropriate to do so. But that's a different question. So I do suggest that the operation of the conditional benefit between non-parties to an arbitration agreement, with one party not subject to injunctive relief, does create a very, very exceptional case. We are that exceptional case. And it has to be remembered that it's in the context of direct action statutes which exist across across the world, actually, but certainly across the European Union, and indeed even in England with the 2010 Act. Direct actions against insurers are one of the realities of the life of an insurer, liability insurer particularly. So, in my respectful submission, it would be misleading for the court to approach this with any fear about what the consequences will be of doing what the CJEU have ordained bindingly should be done. I thought it right to make those general points because I perceived, standing here, I perceived that Lady Justice Andrews in particular was concerned about the impact on London international arbitration, and I do say there is none of any relevance. And indeed, because of the clubs reinsuring, it's not even as though the members of the clubs are going to be adversely affected. I have no idea whether reinsurances were affected, so it may or may not be national for this country. So I think one has to put, as it were, those merits to one side. Now, we have the judgment of the Court of Justice, and although I haven't gone through it with the court, I apprehend that you've all probably read it several times to your heart's content. The critical point is that the touchstone of irreconcilable judgments is whether the judgment in question could have been made by the court giving the judgment of its own jurisdiction. Now, that is coherent. It is what the Court of Justice have said, and it is rational, bearing in mind that they have taken into account the objectives and the purposes of the regulation. Whether you would have arrived at the same conclusion, in a sense, does not matter, with the greatest of respect. It's rational, it may not, it may generate its own problems, it may not. But it's rational and coherent and clearly dispositive. Now, I was conscious this morning that I trespassed, rather, into Miss Dilnott's coverage of the arbitration awards and equitable compensation and the like. I apologise to her, but I hope I've said nothing.
You may have trespassed, but they are intimately related.
Yes, they are. They are indeed. And I apologise for my trespass, but I hope it wasn't a trespass that's caused any loss or damage. But now, my Lord, I'm going to start with the proposition that what the Court of Justice has said is clear, whether it's right or wrong, is clear, and is binding as a matter of statute, and is dispositive on the facts of the present case, as seems to have been recognised by the learned judge. Now, can I just, I hope, on a whistle-stop tour, just provide a couple of propositions as to the role and function of the Court of Justice, which are in my skeleton of paragraphs 32 and following. I think there are three, which I hope set the context. The purpose and function of the Court of Justice as the umpire of the treaties, as it's been called, is to ensure that EU law is both interpreted and applied in a uniform way across the Union. It has the exclusive right to state EU law correctly. Proposition 1. Proposition 2. Therefore, it is essential that Court of Justice judgments, both the reasoning and the operative part, are binding on all member state courts, whichever may have been the referring court under preliminary ruling procedure. And 3, all member state courts must do all they can to ensure compliance with CJEU judgments, even to the extent of disregarding their own national legislation or otherwise binding judicial precedents. Those 3 propositions are rather important in my respectful submission. Can I, on a whistle-stop tour, can I just show you your lordships and ladyships a handful of authoritative statements, which I hope will not take very long. The first is a paper by Professor Lennartz, who is the president of the Court of Justice. He was, to be fair, the president of the court in the present case. But it's in bundle 12. Now, Colin from EPIC has told me what I should refer to. I think it's volume A, volume 12, at tab 126, page 3315. I hope Colin from EPIC will. Am I right? Okay. This is a paper by Cohen Lennartz. Belongs to a debate on.
No, it's page 3426.
I don't have a volume 12.
3315?
No, tab 126.
It's not helping. Perhaps
3315 in the paper.
Tab 126.
3426 in the electronic.
126, yes, 125. 126. 315. Yes, certainly not. No, I think that's, if you'll forgive me, Colin from EPIC, it's not the authorities bundle, that's the core bundle that you've got up. Sorry, do forgive me.
Yeah.
I have 5 volumes of authorities bundles with the Brussels 1 appeal, and I would have expected this document to be somewhere in those 5 bundles.
It's the 5th bundle.
My lady, I think that's because you, in common with me, have double-sided bundles,
Yeah.
and so you just have to multiply the numbers by 2 to
Thank you, Mr Hancock. Which tab?
So we've got adding 7 and multiplying by 2.
126.
It's
126.
126
Thank you.
3315.
By the time you get to 3,426, the discrepancy is much more than 7.
Ah, Lord.
Right. Is this an article headed "No member state is more equal than others"?
Yes. The heading is the primacy of EU law and principle of equality. Yes, and then there's.
I mean,
member
it's not a particularly auspicious start to this trawl through the authorities to go to an article by the President of the Court.
It was just a summary.
Okay.
My
let's
lord,
see.
I'm perfectly.
Come on, where is it? No, I'm not.
It's just the last. It is. He is the president. He is the
I
Lord
know him-
Reed.
I know him well.
the last paragraph.
He is indeed the president. Yes.
3315 at the bottom.
Yeah.
In my view, 3 direct implications flow from the principle of equality of the member states. First, the uniform interpretation and application of EU law are key for guaranteeing that equality. Secondly, the uniform interpretation of EU law needs to be ensured by one court and one court only, i.e. the Court of Justice. And third and last, the principle of primacy underpins the uniform interpretation and application of EU law as interpreted by the Court of Justice. And 3318 the role of the Court of Justice is to apply uniformly in order for EU law to apply uniformly, one court and one court only must have the final say on what the law of the EU is. And then 3320, the concluding remarks, 4 lines down. As the umpire of the treaties, the Court of Justice has the final say on what the law of the EU is. The Court of Justice, and only the Court of Justice, may guarantee that a provision of EU law has the same meaning throughout the EU. If a member state calls into question the primacy of EU law as interpreted by the Court of Justice and engages in a unilateral course of action, it shows disrespect towards the other member states and their peoples and continue to honour the treaties on a reciprocal basis. Such a unilateral course of action also sends the message that EU law does not apply with the same force throughout the EU and that some member states are more equal than others. However, there is no place for unilateralism in the EU since it stands in the way of upholding the values of respect for the unity, the law and freedom. So I started there because what one has there is a very, I would suggest, authoritative, given who Professor Lennartz is, summary of what are the principles lying behind the law, the Court of Justice's function. Now, there is the Costa case, which is perhaps I needn't take you to it in the interest of speed. It's in my skeleton. Core bundle, page 30 at paragraph 37, sets out the principles, and for present purposes, I don't think you need actually look at it. They're set out in our skeleton, and I hope perfectly adequately. Elchinov, which is authorities tab 71 at 1852. Is probably just worth looking at.
I think that's bundle 3 in
Yes.
Lady Justice.
Thank you very much.
Yes,
Tab 71.
tab 71. I was dividing volume 7 by 2, and it didn't seem to work. And this is a case as reported in an English report version, and I think all I need to do is ask the court to go to page 1851, which is part of the judgment, paragraph 26, dealing with a point that my learned friend will doubtless be making. It's settled law that Article 267 of the transport of the Treaty on the furtherance of the Economic Union, European Union, gives national courts the widest discretion in referring matters to the court if they consider that a case pending before them raises questions involving the interpretation provisions of European law or consideration of their validity, which are necessary for the resolution of the case. Now, my learned friend will want that. Now, if I can take you on the following page, page 1852, to paragraph 29. Secondly, it must be borne in mind that it is settled law that a judgment in which the court gives a preliminary ruling is binding on the national court as regards the interpretation or validity of the acts of the European institutions in question for the purposes of the decision to be given in the main proceedings. And then, para 30, it follows from those considerations that the national court, having exercised the discretion conferred on it by the second paragraph, 267, is bound for the purposes of the decision to be given in the main proceedings by the interpretation of the provisions at issue given by the court, and must, if necessary, disregard the rulings of higher courts if it considers, having regard to that interpretation, that they are not consistent with European law. In addition, it is appropriate to point out that in accordance with settled law, a national court which is called upon within the exercise of its jurisdiction to apply provisions of European law is under a duty to give full effect to those provisions, if necessary, refusing of its own motion to apply any conflicting provision of national legislation, that is to say, in the present case, the national procedural rules set out in paragraph 24 of the judgment, and it is not necessary for the court to request or await the prior setting aside of that national provision by legislative or other constitutional means. So it's not just an obligation on the referring court to be bound. It's an obligation which extends to a positive obligation to disregard any contrary national legislative or other provisions. Now that is something that the learned judge simply, the learned judge, Mr. Justice Butcher, that is.
Well, does he refer to Elchinov?
He does, yes.
And what's he say about it?
Can I?
All right, I'll tell you.
Yes, you can. You've got it electronically. I've got it.
I have. It's paragraph 192 and 197.
That's what I've got. Yes.
The principle applied in Elchinov case is, in my judgment, a different one. That principle is that EU law precludes a lower national court from being bound as a matter of stare decisis by a decision of a court higher in the judicial hierarchy, which was inconsistent with EU law as laid down in a reference in those proceedings. That case did not involve issues of res judicata and what has been called the CAPFRA principle. So what do you say about that?
Well, I'm going to come, if your lordship will forgive me, I'm going to come to CAPFRA a little bit later, if I may, to try and give my submissions a coherence that they've
But
otherwise.
he's wrong, you see.
Sorry?
197 is wrong, you say.
197 is wrong in the conclusion that he arrives at. The CAPFRA principle is a rather different principle. If I can leap ahead, the CAPFRA principle is whether a prior judgment has to be set aside. We don't say that that has to be done. Prior judgment can remain a prior judgment, but if it doesn't have to be set aside, then CAPFRA doesn't apply, and Elchinov does. But I will. Now, the PFE case, which is tab 85, my bundle 9, so it could be 4, I think it's 4, tab 85, page 2322.
Which case are you looking for?
PFE.
Is it Pulindigenica?
Yes.
No?
Yes,
Yeah.
that's right.
Yeah.
It's known as the PFE.
PFE case.
Puligenica facilitesco, or then brackets PFE.
Yeah.
Can I take the court to page 2322? Paras 38 down to 42. It should be noted, the judgments goes, it should be noted that in regard that a judgment in which the court gives a preliminary ruling is binding on the national court as regards the interpretation of validity of the acts of the EU institutions in question, for the purposes of the decision to be given in the main proceedings, Elchinov, and case law cited. Accordingly, the national court, which adjudicating as a court of first instance, has complied with its obligation to make a reference to the court for a preliminary ruling under the third paragraph of Article 267, is bound for the purposes of the decision to be given in the main proceedings by the interpretation of the provisions at issue by the court, and must, if necessary, disregard any national law which it considers inconsistent with EU law. Now, that's a much more general view than of Elchinov and learned judge adopted. It should be noted that the effectiveness of Article 267 would be impaired if the national court were prevented from forthwith applying EU law. 40. A national court which is called upon within the exercise of its jurisdiction to apply provisions of EU law is under a duty to give full effect to those provisions, if necessary, refusing of its own motion to apply any conflicting provision of national legislation, or even if adopted subsequently, and it's not necessary for the court to request or await the prior setting aside, so on. And then any provision of national legal system and any legislative, administrative, or judicial practice that might impair the effectiveness of EU law by withholding from the national court with jurisdiction to apply such law the power to do everything necessary at the moment of its application to set aside national legislative provisions that might prevent EU rules from having full force and effect are incompatible with those requirements which are the very essence of EU law. In the light of the foregoing, the answer to the second, and then we go on. Now, so it's a very significant principle which is being operated and repeated, and it's not the limited one which the learned judge, if I may respectfully suggest, adopted. And the last one, perhaps, is the European Patents Regulation opinion, which is pad 72. Assuming it's bundle 7, or from my lady bundle 4. This was an opinion given in response to a request from the Council of Europe for a view on...
My lady, you'll find it in bundle 3.
I've got it,
Bundle 3, yes, thank you.
Thank you.
Sorry, it's dividing these uneven numbers, is it?
Have you got a page number by any chance?
Yes, it's 1895, my lord.
Thank you.
And this is important just to show that it's not just the referring court that is bound. I don't think the court needs to know the background. As I say, this is the court performing an advisory function. And then 1895 at paragraph 83, it should be recalled that Article 267, which is essential for the preservation of community character of the law established by the treaties, aims to ensure that in all circumstances that law has the same effect in all member states. The preliminary ruling mechanism has established aims to avoid divergences in the interpretation of European law, which the national courts have to apply, and tends to ensure the application of by making available to national judges a means of eliminating difficulties which may be occasioned by the requirement of giving European law its full effect within the framework of the judicial systems of the member states. Further, the national courts have the most extensive power, given the obligation to make a reference to the court if they consider that a case pending before them raises issues, and so on. So, and then over the page, the system set up by Article 267 therefore establishes between the Court of Justice and the national courts, plural, direct cooperation, as part of which the latter are closely involved in the correct application and uniform application of European Union law. Also, the protection of individual rights conferred by that order. It follows that. And then all European courts. So it is all member states are bound by interpretations which may be of European instruments, are bound by that determination, not just the individual referring state. And of course, that has is underpinned by the principle described by Professor Lennertz of uniform interpretation and application across the Union, and it's also underpinned by the need to ensure that European law is applied and interpreted uniformly. But a referring court may know whether it's refused a question, but another member state court may not. So a referring court, if the learned judge's judgment were correct, a referring court might take one view of the vires of the Court of Justice, whereas other courts that are in ignorance of whatever was said by the referring court in making the reference will not have that benefit, and will almost certainly then have a different view as to the vires of the Court of Justice. So the underlying principles are clear, and the underlying rationale is also clear, I would submit. My Lord, Broberg and Fenger, which is the most authoritative work on the subject, is in bundle 12, I imagine bundle 7 of my Lady Justice Andrews. Bundle 5, is it? Oh, right. Tab 120, page 3201 and following. Now, this is a thoroughgoing review, and I wonder if I can just, it pays dividends reading as a whole, but if I could ask you to look at page 3203. Well, I suppose I need, no, I'm sorry, 3202 I need to start with. Under 3.3.2, the subject matter of the preliminary question, it's solely for the national court to determine the content of the question it puts before the Court of Justice. In connection with the proceedings before the Court of Justice, the parties to the main proceedings can only submit suggestions with regard to the interpretation of the content of the reference and with regard to the answers to the questions referred. Hence, those entitled to submit observations during the preliminary procedure before the Court of Justice cannot challenge the relevance of procedure of preliminary questions on the grounds that the referring court has decided to initiate proceedings under Article 267 on the basis of a misunderstanding of factual or legal problems. Not only can they nor can they amend or expand, for that matter, narrow the content of the question. This is in particular the case where the party concerned has argued unsuccessfully before the national court for an expansion of the scope of the question referred. And that's footnote 46, which refers to touring tours, which lay at the heart of much of the learned judge's reasoning, which we will have to look at, I'm afraid, in a little detail. And over the page, it is strictly applied in relation to the question of which national legal provisions the preliminary ruling should relate to. I do stress the word national, because the referring court will have its own national rules that it refers, and the Court of Justice is not principally concerned with those. And then it goes on. If the national court has restricted its reference to a legal problem that is derived from a specific rule under national law, not even the most compelling set of observations would persuade the Court of Justice to frame its preliminary ruling so as to have regard to other legal problems that are derived from different national rules. Now, what happened in the present case was not referable to national rules, but was referable to the regulation as a whole. And then there's a reference to the Eurologistic case, and then perhaps more pertinently, the second one, in Sederland, the referring court had only made reference to certain sentences in a national provision. That notwithstanding, the Court of Justice, in order to provide a useful answer to the referring court, decided that the question had to be considered to relate to the whole of the provision. This was, however, not done in order to cover legal issues not mentioned in the reference, but merely with a view to answering the unsolved issue identified by the National Court in such a way that it would not send a wrong signal about the relationship between EU law and national provision in question. Now, not sending the wrong message is inherent in giving a qualified or nuanced answer, I would respectfully suggest. And then we see at page 3205, in the context of supplementing the referring court's presentation of the facts, top of 3205, the court rules of procedure allow it to admit evidence during a preliminary procedure, hence both the party in the main proceedings and any other body entitled to submit observations to the Court of Justice may introduce facts not mentioned in the reference. This applies regardless of whether or not their information has been put before the referring court. Moreover, so as to enable it to better understand the questions referred, the court not only values but sometimes even calls for evidence to complete or explain the background of the facts as stated in the preliminary reference, especially where the referring court has framed its question in general terms. The Court of Justice will be inclined to examine them in the light of the observation of the parties to the main proceedings. Thereby, the court will be able to design its answer to the facts in the main proceedings and the relevant international law. And that's exactly what happened in the present case. And then the next paragraph. Normally, the Court of Justice is particularly open to including contextual information that can clarify the general background to a problem before it, as long as this new information does not cast doubt on the facts that are given. So one can see the extent of the jurisdiction, if that's the right word, of the Court of Justice is somewhat extended. And then 3.3.3.3.1, the degree of fact-finding performed by the referring court, as stated in the preceding sections, the Court of Justice is relatively open to supplementing the facts of the case as laid out in the reference from the commercial court, as long as the supplementary facts complement rather than change the presentation of facts given. So one can see that what the learned judge called trespassing into the facts of the case is something that is actually not a trespass at all. It's something that the Court of Justice regularly does within its jurisdiction. And it is a question of jurisdiction because the learned judge's analysis in terms of vires. And then at 3207, and this is perhaps particularly relevant given the complaint of the learned judge, the Court of Justice shows no reticence in taking into account other EU law provisions than those referred to in the order for reference. That's, of course, in contrast to the national provisions that we've seen earlier. In order to be able to give a useful answer to the questions asked, the court can provide the referring court with all the elements of interpretation of EU law that are relevant for deciding the dispute in the main proceedings. This frequently means the court refers to EU rules which the national court appears not to have taken into account. This is the case not only when the provisions are additional to those which are referred to in order for the reference, but also when those provisions not referred to are relevant to the decision in the main proceedings. As explained in 2.2, when a preliminary question concerns a different EU law rule than that which the Court of Justice finds relevant to the main proceedings, the court will not normally give a ruling by interpreting the EU provision referred to in the preliminary reference, since such an answer would be both irrelevant and hypothetical. Instead, the court will simply answer the question by interpreting the relevant EU provisions. So one can see that the Turing Tour's lack of enthusiasm on the part of the Court of Justice to engage in a consideration of national rules is not mirrored with the Court of Justice's consideration of EU provisions, which may not be those included within the reference, but which can and will be considered by the Court of Justice. And then at 3209, the top paragraph halfway down, I think this is neatly summarised, in a line beginning purpose behind Articles 267. On this basis, the Court of Justice has long been moving towards a more concrete style of interpretation where the preliminary ruling is formulated in a manner that takes into account relevant aspects of the facts in the main proceedings and of the national law, thereby depending on the circumstances and depending on the circumstances, an interpretation will be given which is still formulated in abstract terms, but which in reality is tantamount to application. So once again, what the learned judge regarded as being an excess of jurisdiction is what the court now has long been moving towards. And then the last sentence, the Court of Justice had thought information to decide the application of the law itself. And then page 3210, this is something of a whistle-stop tour, but I hope it's of some relevance to all manner of issues arising. Probably more convenient to have it all done at once. 3210, under the 2.1, National Courts dealing with the case, the response that the Court of Justice gives to a preliminary question binds the referring court to its application of EU law. Hence, if the referring court fails to comply with a preliminary ruling, it not only risks its decision being reversed on appeal, it also constitutes a breach of EU law, so that the Commission may commence an infringement action under Article 8256 TFEU against the state concerned. So it's the failure to apply a Court of Justice ruling is a failure by the state too. And the second paragraph on that page, page 3211, not only the referring court, but also any appeal court which decides on the case in the main proceedings is bound by the preliminary ruling in the case in question. The same applies to any national court dealing with the case at a late stage of the proceedings. The binding effect of a preliminary ruling applies not only to its operative part, but must also be understood on the basis of the grounds for the preliminary ruling. And thus we have in Article 89 of the withdrawal agreement the important word entirety. Now, and then at 3212.
Sorry, just to clarify there, you don't say that the reference to entirety means anything different from the earlier understanding of being bound by the dispositive and the grounds.
Correct.
I'm having in mind paragraph 71 at the moment.
Yes, I understand that entirely, and it may be that the paragraph 71 compelled the court and compels you now to put aside a prior ruling. But for present purposes,
that's not not quite my question,
No.
because to me, correct me if I'm wrong, grounds for a ruling would classically be the reasons for the actual decision
Yes.
reached, whereas you've been telling us
Oh, that wasn't a ground
paragraph
for it wasn't a ground for the
71
ruling.
was not a ground.
I don't say
I'm
that.
saying, do you say there's any difference in the reference in the withdrawal agreement to entirety?
I don't.
I didn't
probably-
understand you to be saying there was a
No,
difference.
I-
but there is an
No,
apparent difference.
I see the point my lady is making. I suspect Miss Norris is probably in a better position to answer this than I. I don't say entirety makes obiter dicta ratio decidendi. If that's putting your ladyship's question in a slightly different.
Thank you.
I hope that's a fair answer. But then we come to the important question of, at page 3212, and for present purposes, the critical one is to the learned judge's jurisdiction and your jurisdiction to consider the vires. 3212, first complete paragraph. Questions concerning the binding effect of a preliminary ruling have, however, arisen in cases where, in its ruling, the Court of Justice has gone beyond the issue referred to it and has answered the question that, strictly speaking, has not been put by the referring court. That we are, in the eyes of Mr. Justice Butcher, where we are. In France, the Conseil d'État had previously taken the stand that a preliminary ruling from the Court of Justice only binds a referring French court to the extent that a preliminary ruling stays within the preliminary question as formulated by the referring court. In contrast, it was legitimate not to follow the court's ruling to the extent that it answered questions not raised in the reference. Thus, for example, if in a preliminary ruling the Court of Justice limited the temporal effect of that ruling without the referring court having asked any question thereon, only the requested interpretation of the relevant EU law would be binding on the referring court, whereas the temporal limitation of that interpretation would not. The approach of the French Conseil d'État was hardly compatible with the principle that the judgments of the Court of Justice are also binding on national courts, which have not made a preliminary reference, and it was particularly unhelpful with regard to cases concerning the validity of EU acts. Fortunately, in its ruling in Société de Groot concerning annulment proceedings against ministerial provision regulating the marketing of shallots, it's an absolutely brilliant case if you want to look at the facts. The difference between a shallot and an onion, which I was unaware of. Because it's fascinating. And how many different
I think
types of shallot.
you better not
No,
elaborate
you're
on
probably
that,
right.
because
I'm
it's
afraid I
rather
got fascinated
indicating
by it.
that-
But it's well worth a read if your ladyship has the time. The Conseil d'État has subsequently reversed its position on the view that the assessment of the lawfulness of the French provision depended on an interpretation of two council directives. The Conseil d'État referred a preliminary question to the Court of Justice in the relationship between the provision and the directives. In its judgment in De Groot, the Court of Justice not only rule on the aforementioned directives, noting that the plaintiffs in the main proceedings had also invoked what is now Article 34 of TFEU, it also examined the relationship between the French rule and that provision, regardless of the fact that the Conseil d'État had decided not to pose a preliminary question concerning the rules on free movement of goods. The Court of Justice concluded that the French rule in question did indeed violate the treaty provisions. Following this preliminary ruling, the Conseil d'État held that although the interpretation of the treaty had not been the object of the preliminary reference, it was indeed binding on the Conseil d'État. So the very situation that the learned judge envisaged was reworked in De Groot, and basically the National Court did not have the power that the learned judge has taken to himself. Similarly, questions concerning the binding effect of a preliminary ruling have sometimes arisen before the referring court when it has been argued that the Court of Justice has exceeded its competence under Article 267 because it has based its preliminary ruling on an understanding of the facts of the main proceedings not shared by the referring court. And then there's a reference to the Arsenal case. We've got to look at the English authorities a little bit. The Court of Justice accepts that a preliminary reference is sought before the facts are established, be that by the referring court or a later appeal procedure, and indeed even after the delivery of a preliminary ruling. EU law allows the referring court to alter its findings in respect of relevant factual legal context, provided that the referring court gives full effect to the court's interpretation of EU law.
So the judge approved what Sir Peter Gross had said at paragraph 208 of his judgment, and he refers to de Groot and says that it allows the court to answer additional or different provisions, different questions, but then says these principles do not permit the Court of Justice to answer questions which are in substance different from those referred to. You say that's wrong.
I do say that the Court of Justice can reformulate questions. I do say that the Court of Justice sometimes does not reformulate them so as to alter the substance of the question referred. I do say that only the Court of Justice can determine whether that reformulation is or is not legitimate. That's what happened in Turing Tours, as we will see. The referring court cannot consider the legitimacy of the extension of the reformulation. The judge was just wrong in thinking that that gave the member state court, or any member state court, a power to regard any judgment of the Court of Justice as not binding.
So just putting it fairly simplistically, a national court refers question A to the European Court of Justice. The Court of Justice decides that it's going to answer question B as well as question A, which wasn't referred to it. The national court has got to apply the answer to question B unless and until the Court of Justice says we were out of order in relation to answering question B, and we shouldn't have done that, and we've revised our view.
Yeah.
That's what it really amounts to, doesn't it?
I wouldn't. Yes, the referring court says we appreciate that we are bound by the answer to question B, but we think question B should not have been the subject of. Yes, and you're absolutely right.
So then there has to be another reference.
There has to be another.
There has to be another reference. There is, of course, my lady, there's a rather important question here as to whether question B is indeed distinct from question A when it comes to the answering of question A.
I follow that in relation to this case. I mean, I think what you're saying is that it's perfectly legitimate for the Court of Justice in answering question A if it considers it is appropriate to give a qualified answer to question A, to have reference to other provisions of European law which have a bearing on the answer to question A. It can't have its hands tied. And if that involves answering question B, well, so be it.
Yes.
And that it may well be what the European Court itself would say if there were a second reference, which there can't be for all sorts of reasons. But I get the distinction. But just to test the proposition, the hypothesis is, suppose we've not got that sort of overlap, still, if the European Court goes out on a frolic of its own, decides a distinct question that was not referred to it, but is a point of European law, that is binding, unless until the European Court itself says, sorry, we shouldn't have decided that, we're reconsidering.
And the answer is to that question is yes, so long as the referring court, as the ultimate fact-finding court, finds facts which render that interpretation binding.
Yes, I mean, there's always the caveat on the fact findings, which is once you apply it, so long as you apply European law in the way in which the CJEU has said it should be applied, it may well be that the national court can say, well, actually that situation hasn't arisen here.
Exactly.
On the facts.
It's what we would call, in the common law world, a distinguishing a case.
Yes.
But your ladyship has it in absolutely. And in answer to my Lady Justice Falk's question, it's binding on the dispositive part and the reasoning which gets to the dispositive part. I don't say that it applies to incidental
Remarks.
obiter dicta. If adopting a piece of English jurisprudential talk is appropriate. And then finally, I hope going through what Broberg and Benger says is quite useful for the court, because it is a very good and authoritative work. And 3215, under the heading of Other National Courts, 3.1 paragraph. In the early days following the entry into force of the Treaty of Rome, it was debated amongst legal theorists what effect a preliminary ruling of the Court of Justice had other than in relation to the main proceedings. While some legal writers then took the view that preliminary rulings are not generally applicable and that, legally speaking, they don't bind courts other than those involved in solving the dispute giving rise to the preliminary ruling, today the prevailing rule is the opposite. Then indeed, the general significance of a preliminary ruling to matters other than the main proceedings which have given rise to it may be likened to the effective judgment of a national supreme court in a continental legal system that generally extends beyond the dispute which the judgment is immediately concerned. First, as a matter of principle, preliminary rulings are declaratory, that is to say, they lay down how existing EU law must be understood as from the day of its entry into force. The interpretation given by the Court of Justice thus constitutes an integral part of the EU rule in question. And then down a bit, second, the preliminary ruling procedure is aimed at ensuring a uniform interpretation of EU law. That's one reason why I showed you Professor Lennox. To achieve this objective, the interpretation of an EU rule given in a preliminary ruling must have general validity and also bind other courts having to interpret that rule. Third, in several respects, the Court of Justice has shown that it attaches general validity to its own preliminary rulings. And then down to the bottom of the page, fourth, it is precisely the general effect of preliminary rulings, which is the reason why Article 23 of the Court's statute vests in the Member States and the Commission, as well as the EU institution, body, office and agency which adopted the Act, which is in dispute, a right to make submissions in connection with the preliminary ruling procedure. And that of course, is here we had a large number of observing parties making their thoughts felt. Fifth and finally, a violation by national courts of a provision of EU law whose meaning has been elucidated in a preliminary ruling may give rise to state liability. And then the next paragraph, the general effect of preliminary rulings means that all national courts are obliged to apply not only the operative part of a preliminary ruling, but also the ratio when interpreting EU law. This obligation exists whether or not the national court in question sits as a court of last instance. So we have a situation where the EU, the CJEU, makes a pronouncement on the true interpretation of EU law as to how it should be interpreted and how it should be applied. That applies to every member state, whether a member state has or has not been involved in the reference, whether it knows what questions have been referred, whether it's got any capacity to inform itself as to whether the vires of the Court of Justice have been infringed. This leads only to one conclusion, and that the learned judge simply did not have the power to override the binding effect of the judgment. And there is a more recent, if I can ask you to look at the RS case, which is, I say it's probably bundle 5 for my lady, tab 106. Now this is, I mentioned the more recent decision, which is post-Brexit, and therefore not binding, but it is something to which one, the court should pay due regard. And it's the RS case, which starts at 2951, and perhaps I can just take you straight to 2963. So this is post implementation period. This is not binding, but it's to be given due regard. And this is what the European Court says at para 72. In addition, since, as has been pointed out in paragraph 52 above, the court has exclusive jurisdiction to provide the definitive interpretation of EU law, the constitutional court of a member state cannot, on the basis of its own interpretation of provisions of EU law, including Article 267, validly hold that the court has delivered a judgment exceeding its jurisdiction and therefore refuse to give effect to a preliminary ruling from the court. So that's a clear statement that it can't, a national court cannot do what Mr. Justice Butcher did. In that regard, it must be stated the preliminary ruling procedure provided in Article 267, which is the keystone in the judicial system established by the treaties, sets up a dialogue. And then perhaps para 74, judgment delivered in the context of that procedure is binding on the national court as regards the interpretation of EU law for the purposes of resolving the dispute before it. And then see vice. And then over the page, para 27. In addition, since the interpretation which in the exercise of the jurisdiction conferred on it by Article 267, the court gives to a rule of EU law, clarifies and defines where necessary the meaning and scope of that rule as it must be, or ought to have been understood and applied from the time at which it was entered into force. It must be found that an ordinary court is required in order to ensure the full effectiveness of the rules of EU law, to disregard in a dispute before it the ruling of the national constitutional court, which refuses to give effect to a judgment given by way of preliminary ruling by the Court of Justice, even where that judgment does not arise from a request for a preliminary ruling made in connection with that dispute by that ordinary court. So there, the Court of Justice, after Brexit, and it was the Grand Chamber again, said national courts cannot rule on the excess of jurisdiction of the Court of Justice. And that really is the end of just about everything that the learned judge then devoted considerable attention to. I haven't
Is it the end of paragraph 41 of Touring Tours?
Yes, I'm going to show. Can
So why?
I'm sorry, my lord.
Is it the end of paragraph 41 of Touring Tours? And if so, why? And if we see that paragraph cited under point 5 of Sir Peter Gross's principles, which the judge adopts at paragraph 208 of his judgment. And the paragraph said, it's clear from the case law of the Court of Justice, and this is the Court of Justice speaking, that if the referring court expressly stated in its order for reference that it did not consider it necessary to ask a question, or if it implicitly refused to submit to the Court of Justice a question raised by one of the parties, the Court of Justice may not answer that question or take it into account in the reference for a preliminary ruling.
Now, the Court of Justice will not answer it, But what happens when the Court of Justice does answer it? Then by definition there is no excessive jurisdiction because it has done what it's there to do.
Okay.
That's why that is mistaken. And touring tours,
Sorry, I don't-
is, oops, I'm sorry.
If I understood correctly, you're not saying it's mistaken from the point of view of the CJEU, it's just that they are the ones who make that decision.
Correct. And they do so,
And not the National Court.
and not the National Court, or National Courts plural, because referring Court A may have had an express refusal to refer. When there is an express refusal, it's made express and the reasons are set out, as happened in touring tours, just as a matter of interest. But other courts won't know, because the only instrument that is made available to the other observing states and parties, the only instrument that's made available is the reference itself, not the judgment which gives rise to the...
Well, you've made that point. But
Yes,
I'm assuming that that may or may not be debatable, but you say the answer to my question is that is only that the Court of Justice should not really answer the question, but if it does, everybody else is bound by it.
Yes, if it does, it's got jurisdiction to do what it wants to do, and it can always say we don't have jurisdiction to answer this question. And there's a case, the Kleinrock Benson in Glasgow, where that's what they did. The learned judge has extracted from that rather more than is appropriate. But yes, it's the CJEU which determines whether it's got jurisdiction. And sometimes it says we decline to answer a question because we don't think we have jurisdiction to do it. So they decline. And in the case of touring tours,
you can go so far, I would have thought, as to say, well, since the CJEU is not a court of precedent, it can turn its back on touring tours and say, well, we're not going to follow that rule anymore.
absolutely. I mean, that's one reason why I wanted to show you a number of cases, because it's not a court of precedent, but it is a court rather like the Cour de Cassation in France, which has a development of jurisprudence which becomes settled law. That's why I showed you a number of cases.
But even if you have got settled law, I mean, everybody thought touring tours was the last word, but obviously you say, CJEU can say, no, it isn't the last word.
Yeah.
We can decide that we're no longer going to be bound by that self-imposed discipline. And we're going to answer a completely different question that has specifically not been referred to us, and there's nothing you can do about it.
No, well, that's actually it. Perhaps it would be helpful to look at touring tours, which is bundle 9, so it could be 4 or 5 for my lady, tab 90.
Number 4.
Bundle 4, I'm good. It's really, I mean, since it was central to the learned judge's reasoning, I think it is probably quite important just to have in mind exactly what it was about. It's page 2463. And it was a case concerning the carriage of illegal migrants into Germany under the Schengen arrangement. And there was a question as to whether the conviction of the coach company was sound in European law. I'm not sure that going through the precise route by which the German courts came to the conclusion they did, but the important element is at 2472, where we have the questions set out at paragraph 32, in what I can only describe as a fairly detailed do Article 67.2 of the TFEU and Articles 20 and 21 of the Regulation 562 preclude provision of national law of a member state which has the effect of requiring coach transport undertakings operating regular services across the Schengen internal border to check their passengers' travel documents before crossing an internal border in order to prevent foreign nationals not in possession of a passport or residence permit from being brought into the territory of the Federal Republic of Germany. And then there was reference to a specific number of specific regulations. I've been asked to refer to paragraph 30, yes, of course. The paragraph 30, page 2471. The Federal Republic of Germany brought an appeal on a point of law against that judgment, the Verwaltungsgericht, before the referring court, the Bundesverwaltungsgericht, Federal Administrative Court, arguing inter alia that EU law and specifically Directive 2002/90 and Framework Decision 2009/46, which are special provisions compared with those of Regulation 562, require the imposition of penalties for infringements of transport prohibitions, such as those laid down in paragraph 3. Now, yes, I see the point of being made. Now, when we look at page 2472, paragraph 34, consideration of the questions. By those two questions, I don't think I showed you the same question, but I don't think it matters, which in each of the joint cases which should be examined together, the referring court asks, in essence, now I think every time you see the CJEU refer to a question, it says in essence, it sort of reformulates straight off, whether Article 67.2 and TFEU 20 and 21 of Regulation 562 must be interpreted to the effect that they preclude legislation of a member state such as that at issue in the main proceedings, which requires every coach transport undertaking providing a regular cross-border service within the Schengen area to the territory of that member state to check the passports and resident permits of passengers before they cross an internal border in order to prevent the transport of third country nationals not in possession of those travel documents to the national territory. Now, as a preliminary point in relation to the scope of the questions referred, it should be noted that they are limited to an examination of the provision of paragraph 63 of the Aufgent in the light of Article 67 and Articles 20 and 21. However, the Federal Republic of Germany, as a party to the main proceedings, submitted both in its written observations and at the hearing before the Court of Justice that the transporter's obligation to carry out checks subject to the imposition of a recurring fine under paragraph 63 of the Aufgent does not contravene EU law. Now, some provisions of Directive 2002/90 of Framework Decision 2002/946 of the additional protocol under Directive 2001/5 require member states to impose obligations on passenger carriers to carry out checks such as those laid down in paragraph 63 of the Aufgent, and to impose appropriate sanctions on transporters which knowingly help third country nationals to enter the territory of a member state to pass through the territory. So a completely new point was being raised as to whether there was a requirement on member states to impose obligations. However, they say, 37, it is clear from the requests for a preliminary ruling that the referring court, in reply to that line of argument already put to that court by the Federal Republic of Germany in support of its appeal, expressly stated that it did not need clarification regarding the possible effect of 2002/90 of Framework Decision and of 2001 on the reply which had to be given to the questions asked, explaining clearly why it was of that opinion. So there was an express refusal to refer to that which had been added by the Federal Republic of Germany, and there were reasons given so that anybody reading the reference would know that. Therefore, it must be stated that the referring court did not refer in its question submitted for a preliminary ruling to any of those three provisions of EU law or indeed the additional protocol. In that regard, it should be recalled that it is for the referring court alone to determine and formulate the questions to be referred for a preliminary ruling concerning the interpretation of EU law. Blah, blah, blah. 40. Although the referring court is at liberty to request the parties to the dispute before to suggest wording suitable for the question to be referred, the fact remains it is for that court alone ultimately to decide both its form and content. It is also clear from the case law of the Court of Justice that if the referring court expressly stated in its order for reference that it did not consider it necessary to ask a question, or if it implicitly refused to submit to the Court of Justice a question raised by one of the parties, the Court of Justice may not answer that question or take it into account in the reference of a preliminary ruling to that effect, and then so on. So that is, first of all, there was a specific argument which had been raised by the Federal Republic of Germany, which related to a completely different nature, a different obligation, which had been specified and rejected, specifically not part and parcel of the reference, and explained not why that reference was not made. And the Court of Justice itself held that it wasn't appropriate to consider that question. It did not feel the need to answer the questions actually posed to consider those provisions, and it was not the national court. It wasn't the court of the Federal Republic of Germany to hold that any conclusion by the Court of Justice on the substantively extended question was somehow an excess of jurisdiction. That comes back to whether a national court can do it rather than the Court of Justice doing it. And I say only the Court of Justice can say what it's going to consider. And it's going to consider anything which is necessary and which it regards as necessary to give assistance to the referring court, and not to give the wrong message. So Turing Tours was it doesn't support the proposition that member state courts, local courts, can review the vires of Court of Justice decisions and can choose not to be bound. It's for the Court of Justice. And that's what Turing Tours, in truth, establishes. The very point that the learned judge needed was that the national court has the jurisdiction to rule on the vires, and that's the one thing it doesn't support. So when one looks at the learned judge's judgment, if we may, on excess of jurisdiction, it starts, I think, in the core bundle at page 265, paragraph. It starts at 204, but I think actually one goes back a little bit to 203. Paragraph number. And I say that because the proposition that the learned judge provides at the last three lines of 203 are in truth a linking factor with what follows, where he says, moreover, the CJEU does not have jurisdiction to give ruling in circumstances where the national courts will not be bound by any interpretation it may give. There seems to be an element of chicken and egg about that, but there's a reference to Kleinwort-Benson. And I just wonder if I can show you that. It's the authorities bundle, page 987. tab 43.
Volume 2.
Volume 2, is it? Yes, it's volume 2. Yes, I can now halve it. That was a case arising out of a series of disputes about swaps in the late 80s and early 90s as to whether certain local authorities in England and Scotland had the power to conclude various swaps agreements with certain city institutions. I'm sure my Lady Justice Andrews will have come across this a lot. And it was held that Glasgow City Council, in this particular swaps arrangement, was acting ultra vires, and therefore the swaps arrangement was void. And Kleinwort Benson then sought restitution. And there was a dispute as to whether they were entitled to sue Glasgow City Council in England or in Scotland. And that raised a question of the true meaning of the 1982 Civil Jurisdiction and Judgments Act, which was, still is, very largely, but not wholly, modelled upon the Brussels Convention as was. And the question was referred to the Court of Justice as to the true meaning of the Civil Jurisdiction and Judgments Act, just an English, UK statute in relation to a debate between England and Scotland. And the European Court of Justice held that it did not have the jurisdiction to rule upon a national statute, even though it was in some respect very similar to the relevant European Convention. And at page 1012, under the heading of the jurisdiction of the court, they say, it's common ground that the purpose of the interpretation which the court is asked to give of the convention provisions at issue is to enable the national court to decide on the application not of the convention, but of the national law of the contracting state to which that court belongs. Under those circumstances, the question arises as to the jurisdiction of the court to give a preliminary ruling on the question submitted by the Court of Appeal. Far from containing a direct and unconditional renvoi to provisions of community law so as to incorporate them into the domestic legal order, the Act of 1982 takes the convention as a model only and doesn't wholly reproduce the terms. Though certain provisions of the Act of 1982 are taken almost word for word from the Convention, others depart from the wording of the corresponding Convention provision. That is in particular Article 5.3. Moreover, express provision is made in the Act of 1982 for the authorities of the contracting state in question to adopt modifications designed to produce divergence between the provisions of Schedule 4 of the Act and corresponding provision of the Convention as interpreted by the Court. Accordingly, the provisions of the Convention which the Court is asked to interpret cannot be regarded as having been rendered applicable as such in cases out with the scope of the Convention by the law of the contracting state. And then they go on to just refer to the provisions of the 1982 Act. And then over the page 1013, Para 23. Accordingly, if the court were to declare that it had jurisdiction to give a ruling in regard to this question, its interpretation of the provisions of the Convention would not be binding on the national court, which would be bound by the interpretation of the court only if the Convention were applicable to the dispute. It cannot be accepted that the replies given by the court to the courts of the contracting states are to be purely advisory and without binding effect. that would be to alter the function of the court as engaged in the Protocol 71, namely as a court whose judgments are binding. So what the Court of Justice said was, we are obliged to give judgments that are binding, although when we get to the patent case, they had started to give advisory opinions. But they couldn't give any binding ruling on the meaning of the convention, because the convention wasn't in question. It was the 1982 Act that was in question. And therefore they said, because we have to give rulings which are binding, we can't give rulings that are merely advisory. Now, that is, I hope, to put the proposition the learned judge set out at the last 3 lines of paragraph 203 into its proper perspective. It doesn't say that if the CJEU gives a judgment which is binding on all member states, it isn't binding because it's not binding. You see what I mean? Which is, in a sense, what the learned judge concluded. So I would respectfully suggest one needs to have some caution applied to that particular proposition as to what is and what is not binding. And then we go on to the court's the club's jurisdiction ground, and the conclusion of the learned judge that he's got the power to review is justified by 7 principles, which are at 266 and 267 of the judgment. And most of them are pretty uncontentious so far as they go. One at 266, preliminary reference.
Which paragraph are you at? Which paragraph?
One at the top of page 266, little in brackets 1.
Which paragraph?
Oh, paragraph 208 of the judgment, page 266 of the bundle.
It's fine. Just if you could give me paragraph numbers.
Yes, I will. Yes, it's the paragraph numbers in this particular passage are slightly perplexing because they're surrounded by brackets and by square brackets.
Yes, I've got it.
So it's ordinary brackets 1. The preliminary reference procedure is intended to be based on judicial dialogue between the national courts and CJEU as a function of an instrument of cooperation. I've got no problem with that. 2, the procedure involves a division of responsibilities. In this division of responsibilities, and then they quote that it's for the deciding court to define the subject matter of the questions which it proposes to refer. And then back to ordinary brackets 3, it's also for the referring court to formulate the questions referred, as was said in Turing Tours, and then they quote paragraphs 39 and 40 of Turing Tours. Now, you've seen how it's for the court, the referring court, to formulate the questions, but they can be reformulated, as we see in little paragraph 4. In answering the questions referred, the CJEU may do so by reference to additional or different provisions of EU law, and may reformulate the questions posed in order to answer them and to assist the national court. That's a proposition which I rely upon. And then it's said in Broughton and de Groot. And then at the CJEU, the bottom of that paragraph, the CJEU may, in order to answer the question referred, answer a logically anterior question, which is a necessary step to the reasoning in order to answer the question referred. Once again, that is no problem. So there is the possibility that the court can, in providing an answer, can extend beyond what is strictly limited by the reference. These principles, he says at paragraph 5, do not permit the CJEU to answer questions which are in substance different from those referred. Specifically, the court may not answer questions which the referring court has expressly or implicitly refused to refer. As it is
You say that's wrong.
I say it's right to say that the Court of Justice can refuse to answer a question which is in substance different from that which has been referred. But it's a right in the Court of Justice. And it's got to be substantively different rather than, as it were, providing a nuanced answer to the question actually referred. But if it's being relied upon as justifying the right and jurisdiction of a member state court to interrogate the vires of the Court of Justice, then I do say it is going too far. And then over the page, 267, little ordinary paragraph, little bracketed 6, the need for the CJEU to limit itself to the questions referred and not to alter the substance of the questions referred is reinforced by the need to safeguard the rights of interested parties who may wish to invoke their right to make observations to the court. See Phytheron. Now, I think we should just look at Phytheron, but that, of course, is something of a double-edged proposition, because non-referring courts, other member state courts, will only be able to read the judgment of the Court of Justice of the European Union and won't be able to form any view about what was and was not specifically excluded from the reference. Now, the Phytheron case is at tab 45, so I would guess it's bundle 2, page 1024. Now, that was a dispute between a buyer and seller about the buyer's cancellation of a contract for the supply of goods from Germany when the goods had in fact been manufactured in Turkey outside the EU. And there was an issue about the breach of trademark and the right of the French buyer said that the French law precluded the purchase of goods manufactured outside the EU bearing a given trademark. And the questions referred concerned whether the goods fell within the prohibitions under EU law. There was then a point that arose as to whether, in fact, the goods had been manufactured in Turkey or whether they had previously been manufactured in Germany, transported to Turkey, and then transported back to Germany. And the Court of Justice was unhappy about dealing with that particular change in the substance of the case. And if you could turn, my lord, to page 1028, going over to 1029, one can see why it's just a completely different animal that was being proposed. And at paragraph 10, However, during the proceedings before the court, that's the CJEU, it was stated that the place of manufacture of the product in question was in fact Germany, from where it was thereafter exported to Turkey, and that the batch at issue had been acquired there from a Turkish subsidiary of the German Höchst Group by an independent trader who then sold them to Phytheron. For reasons set out in paragraphs 12 to 14 below, the court in the present case can answer the national court's questions only on the basis of the facts as they appear from the order for reference. Were the court to base its ruling on the facts mentioned in the course of proceedings before it, the very substance of the problem raised by the questions referred would be changed. It would then have to address a question of principle which it has not yet had occasion to decide on the basis of facts which required clarification to enable a proper answer to be given. Furthermore, in the context of proceedings raising an important point on the extent of rights which a trademark owner may derive from the mark, there are specific reasons why the court should not depart from the facts as stated in the reference, given that the owner of the mark, not being a party to the main proceedings, cannot put his arguments to the court. Finally, 14, to alter the substance of questions referred for a preliminary ruling would be incompatible with the court's function under Article 177 of the treaty and its duty to ensure that the governments of member states and the parties concerned are given the opportunity to submit observations. Now, one can see that setting out a completely different factual situation was...
Well, I mean, you don't really need to take much time on this. I mean,
No, I won't.
This is obvious.
Yes, then I won't, my lord. I thought it, since the learned judge referred to it, I thought it was right just to...
Well, I mean, your complaint is that this is, if it's a sort of superficially accurate list of 7 propositions, they're not the relevant 7 propositions.
No, I've got a relevant, I think, 8 propositions that I might... yes, they are 8. If I can
There's
just...
one proposition you have, which is that the Court of Justice's decision that it decides to answer in relation to the case in question is binding.
Yes.
Full stop.
That's, yes, that's it. All of my 8 propositions go to that one proposition. I'm quite happy...
Some of yours are alternative, but the crux of it is what my lord says.
Absolutely. If I could adopt what the European Court of Justice would say, in essence, yes.
We nearly spent a day on this.
Well, we spent a day. I did trespass into.
I mean, I remind everybody of what I said this morning. You know, what concerns this member of the court, at least, is the question of equitable compensation and all that sails in that part of the case. It seems to me, complex and difficult and interrelated with the questions we were discussing this morning, namely where the line is to be drawn between the regulation and arbitration.
I could not agree more.
And that cannot be, I'm afraid, salami sliced into the Brussels appeal and the arbitration appeal, because the Brussels appeal is essential to the arbitration appeal and vice versa.
Absolutely.
So, I mean, whilst I much enjoy trawling through decisions of the Court of Justice, particularly late in the afternoon, I find that particularly pleasurable.
It is absolutely a marvellous way of spending an afternoon, you're right.
Yes. Please do bear that in mind, because the more argument that can be devoted to that point, the more assisted the court.
My lord, I'm acutely conscious of that. I see that. I felt the learned judge went to such lengths.
Yes.
And I felt it unfair to the learned judge not to consider the lengths to which he went in his academic.
Well, he may well be right, and no doubt we will have submissions to that effect. But if he were not right on this particular point, it doesn't end the case.
Oh, absolutely no. It ends the case on the recognition under the.
But, you know, commercial cases tend to be about money.
Yes.
Mr. Young.
Oh.
And That is actually what we're interested in.
In the words of Tim Rice, you are preaching to the perverted.
Yes. Okay.
It is Tim Rice's version of that.
Yeah.
My lord, absolutely. I could say that the Court of Justice, whether rightly or wrongly, has set out the boundaries of irreconcilable judgment in Article 8.
And whether it's bonkers or not, it is what it is.
Yeah.
Right? And now we have to consider how it affects this case, which
Yes.
you have pointed out to us is unlikely to ever be repeated. One might add an epithet to that, but I won't.
I can imagine what it is.
But the point is, we have it seems to me, extremely difficult decision, if that were the position on your appeal, of deciding actually what happens. I think it comes down to the point I just made. I won't repeat the interrelation.
My lord, I could not agree with you more. I agree with absolutely every word that you've uttered.
But the difficult bit is that there aren't. I mean, these authorities are all fairly well known. I mean, I don't pretend to remember them because I never do. But when I see them again, there they are. But what's not well known, I think, is what is the interrelation, the interrelation between the regulation and arbitration. It attracts a hugely, what should we say, very great excitement amongst practitioners and amongst commercial parties because they think that they're being interfered with in a particular way. But you touched this morning on what, I think is really the heart of the case, which is what is the justice of what occurred? You, I think, began to make a submission that what Spain did here was entirely justifiable. And not only justifiable, but completely understandable in the chronology of events. And that therefore, because there was no contractual relationship, and you didn't know what the contractual relationship was, and you weren't therefore taking advantage of some kind of loophole or attempt to circumvent the arbitration agreement, you were just doing what a sovereign state might be expected to do, which is bring proceedings under the regulation in the state, in the jurisdiction in which it was supposed to bring those proceedings. And it may have been a sidewind. I mean, I'm elaborating your argument for you, but it shouldn't be taken that I haven't made my mind up about any of this. You happened as a sidewind to bring in insurers because they were there, but the case was much bigger than that and all about what happened in the pollution incident and so on, quite perfectly entitled to bring it in Spain. And actually, the pay-to-be-paid clause is an incidental thing, not something that you're getting over by a sidewind, and you shouldn't be subject to damages for failing to adhere to an arbitration clause in all those circumstances, least of all when an arbitration clause is nothing to the point as to the determination of liability. What's really to the point is the pay to be paid. And yet that's not what you're being given damages for.
Indeed.
So, I mean, I'm sorry, that's a sort of stream of consciousness view, but that's what worries me. All of that, all of the above.
My lord, it was both a valuable stream of consciousness, I would say that, wouldn't I? But actually a very apposite stream of consciousness. I feel...
Maybe completely wrong, and I know that Mr Hancock will say it's not only wrong, but dangerous.
Yes, and he would say that, wouldn't he? Your lordship is... Well, all I can say is your lordship is right. I've, in a sense, I've gone through lots of other numbered propositions, but I've gone through why the judgment of the Court of Justice, for good or ill, is binding and why it should have been applied, and there are no exceptions.
And there it is in your skeleton argument.
And it's there, and it's...
But the answer to the question, if what I put to you, why what I put to you is in your submission right, I would find out, if I'm not only speaking for myself, very helpful. Because it seems to me it's definitely not self-evident. Whilst attractive at first sight.
Well, there are two, I suppose there are two different things. There is the recognition of the judgment under the regulation, which is not prevented, we say, by any of the provisions of Article 34, either 1 or 3. What that does in terms of enforcement as an English judgment is going to be affected by what effect is given to the arbitration award, whether it can operate as a set-off or whether they are two parallel jurisdictions. So,
or whether the arbitration, well, set-off maybe, but the first question is it an Article 34.1?
yes. And
the Court of Justice doesn't say it is.
well, the Court of Justice says it is not, so far as the judgment of Mrs.
Yes.
Justice Hamlin is
It's not the award.
And I must respectfully say that to construe the Court of Justice as disagreeing with the Advocate General, Michael Collins, on this is...
And they did disagree with him about it.
Oh, when they disagreed with him, they made it perfectly jolly
Well, I
apparent.
mean, I was always taught that, and unless they say they disagree, they don't generally.
Yes.
But in this case, where they make a completely different decision, it's rather more difficult to apply that.
Well, perhaps we could just look at what the learned Advocate General said. It's at
Right.
page 20 of the Authorities Bundle 1. So I'm with confidence I can say this is Lady Justice Andrews Bundle 1. At the only time I can be confident.
It's all right. I've reverted to once my battery is back up. I will revert to the electronic copies to make
Well,
it easy for everybody.
I'll try and make sure that everything is completely identified. Page 20, 71, the third question. This is the Advocate General. And I think I can go over the page to para 73, page 21. According to the court's case law, Article 34.1, Regulation 44, the Brussels Reg, must be interpreted strictly inasmuch as it constitutes an obstacle to the attainment of one of the fundamental objectives of that regulation. It may be relied upon only in exceptional cases, whilst by virtue of the proviso in 34.1 of the regulation, the member states are in principle free to determine the requirements of public policy.
I'm sorry, I can't see where you are.
Paragraph 73, my lord.
Oh, thank you.
I am so sorry.
Too
I'm
behind
sorry.
you. Thank you.
I wasn't watching your lordship's eyes. Para 73.
Mm-hmm. Yeah, but that, I mean, Moroni is uncontroversial, right?
It's uncontroversial, and it's difficult to see that the Court of Justice could have had any trouble with it. The regulation defines the limits of the concept. Consequently, while it's not for the court to define the content of a member state's public policy, it is nonetheless required to review the limits within which the courts of that member state may have recourse thereto in order to refuse to recognise a judgment emanating from the court of another state. It's also apparent from the court's case law that reliance upon the concept of public policy is envisaged only where recognition or enforcement of the judgment given in another state will constitute a manifest breach of a rule of law regarded as essential to the legal order of the member state in which recognition is sought of a right recognised as fundamental within the legal order. In Hoffman, the court held that reliance upon the concept of public policy, which is unavailable save in exceptional cases, is in any event precluded when the issue concerns the compatibility of a foreign judgment with a national judgment. That's rather important in the context of my learned friend's reliance upon Hoffman and Creed. The issue thus falls to be resolved on the basis of Article 27.3, now 34.3, Brussels Convention. Reference may also be made to the Gennard report, which I've shown you. Matter of public policy, it shouldn't be interpreted too widely. Moreover, as Advocate General Wahl observed in his opinion in Salzgitter, 34, 2, 3 and 4 of the regulation constitutes a lex specialis in relation to Article 34.1, which of course is of general nature. To the extent that the other exceptions address relevant public policy considerations, the latter provision is inapplicable. I therefore agree with the French government's observation that the EU legislature intended to regulate exhaustively the issue of res judicata and or irreconcilability by means of 34.3, 34.4 of the regulation, thereby excluding the possibility of recourse to the concept of public policy in that concept. So he concludes that res judicata, whilst it may or may not be regarded in any individual member state as a matter of public policy, is not within public policy as interpreted in Article 34.1. Was in relation to both the judgment and...
Well, and 78 says by reason of the existence of a prior domestic arbitral award.
Yes.
Yes, but that's the only reference there to an arbitral award.
Yes, exactly. And he hasn't even started on the New York Convention or how it all fits in with the scheme of the recognition of judgments in the EU. I mean, it's just a throwaway line.
If I may just ask...
general use throwaway lines.
Well, no.
You should be more charitable than that.
All right. There's no reasoning behind it, is what I'm saying.
Well, the reasoning
is Article 34.1 is designed to be exhaustive of what constitutes public policy. That's a circular argument with respect.
My lady, perhaps I could also refer your lordship to a slightly earlier part of the Advocate General's opinion, because it is helpful to look at all of it. The Advocate General obviously concluded that the club was right on 34.3. And in the context of his discussion of 34.3, he gave an example of a New York Convention award.
Yeah.
So he did consider at paragraph 68,
68, yeah.
the New York Convention.
Yes. But his conclusion is that res judicata is not within public policy concept of 34.1, because irreconcilability is dealt with exclusively within 34.3 as the lex specialis, if one has to resort to Latin. And
the reason I struggle with that is that lex specialis, if you look at Article 34.3, it's referring to judgment.
Yes,
it's not referring to arbitral awards.
No, but it arises in the context of the enforcement of an arbitration, the embodiment of an arbitration award in a judgment.
But 34.3 isn't limited to that, it's judgments generally.
Well, I take your ladyship's point, but the learned Advocate General regarded the true operation of 34.1 as not including within public policy res judicata, because irreconcilability was dealt with in 34.3. And of course, it's outside the concept of arbitration because of the arbitration exception. And here one has the real problem.
Indeed.
That Article 34.3, Article 34 is exhaustive of the rights of an incoming state to refuse to register an incoming judgment. Now, that's under the terms of the regulation, and the regulation is very clear and limiting as to what the regulation will provide to justify non-enforcement. And then suddenly, under the heading of public policy, you have something which is entirely out with the regulation, having the effect of compromising the clear and automatic operation of the regulation. So it's all of a piece, as long as one remembers that arbitration is not embraced within regulation at all, and therefore cannot be invoked. It would be ludicrous to say Article 34 is exhaustive of the rights, the very limited and exceptional rights of refusal, but there's something else in a national law which justifies relying upon something which is wholly outside the regulation, having the effect of stymieing the regulation enforcement.
Having reminded myself of paragraph 68, of course, the problem that the Advocate General has referred to looms large, if you're right. Absolutely looms large. It means that there's the potential for an arbitral award being enforced in another EU state under the convention, but because it's a domestic award, it can't be enforced here under the convention, and therefore you're worse off if you try to enforce in your own state, which might be regarded in some circles as somewhat undesirable, Mr. Young.
Well, I can
It may well be that it's right, but that's the natural concomitant of your argument.
The learned Advocate General was aware of this point, and then he proceeded in considering the third question on the premise that he was wrong as to the true effect of the true meaning of the word judgment.
No, I don't think he did. I think he proceeded on the premise that he was right, and therefore it didn't.
No.
It didn't cause a problem.
With respect, my lady, he made it plain that.
You're referring to the first part of paragraph 71.
Yes.
Yeah.
So he was saying, all right, I can see that the court may take a different view of irreconcilable judgment in Article 34.3. Let that be assumed. Then what? And he then said, even so, res judicata is not embraced within the true interpretation in Article 34.1 of public policy.
It also explains why he dealt with it so succinctly.
Well, you'll think this most unlikely coming from me, but succinctness is sometimes an advantage.
Well, you said it, Mr. Young, not me.
Yeah, yes. I'm not unaware of the ironies inherent in it. But he's analysed it, and he said basically, if you want to rely upon res judicata, you can't do it under 34.1. That is not what public policy is there to do. And 34.3 deals with res judicata. And if there's something outside the regulation, then it's outside the regulation, which it is. And it may give rise to novel, perhaps oddities. But that's the EU law. You cannot use a non-regulation, something wholly outside the regulation, to defeat enforcement under the regulation. And one has to remember, this is something that I referred to as an irony in my learned friend's case. It may actually generate an issue with Stoppel going the other way. That the whole premise of the argument before Mr. Justice Hamblin was that there had to be utility in getting a Section 66 judgment, a utility in excess of having the award. That can only be premised on the basis that the award didn't achieve or didn't have the character of being enforcement refusing.
Wouldn't a better characterisation be may not, because the utility didn't involve a definitive.
That is true, my lady. That's absolutely right.
That's why we're.
But there would be no utility. There would be no utility at all if the existence of the award were itself sufficient.
Well, that hadn't been determined.
The premise of the argument that there was utility is that the arbitration award was not enough. That was the very premise, and that was the issue estoppel which underlay the entire
you see all kinds of usefulness in getting a Section 66 registration, not least because it puts paid to challenges to the validity of the award, at least domestically, because it can the winning party can then see off arguments that it was all procedurally irregular or.
That's not the Section 66. That's the Section 67 and Section 72. That's not the Section 66. They were different applications. The Section 67, I would completely agree with that, but not Section 66. Because Spain brought its own Section 67 challenge on the jurisdiction of the arbitrator, which was then dependent upon whether there was an arbitration agreement under Section 80. The club brought its application under Section 66.
Yes,
there were two quite different ones.
So
The
Mr.
utility
Young,
of the Section 66 is
to-
completely unaffected by the utility of the Section 67.
So, Mr. Young, you were doing all this, going to the Advocate General, in order to explain to me why I was wrong to suggest that the answer to question 3 did not preclude an issue estoppel based upon Mr. Schaff's award,
Yes.
as opposed to a judgment. And you said we had to look at what the Advocate General said because the court did not expressly disagree with him.
The Advocate
Now,
General.
can you show me how you make that good by reference to the Court of Justice's judgment?
Well, if one looks at reference was made to paragraph 71 in the Advocate General. If I can just show you that.
Well, we've read that.
Domestic, it's by reason of the existence of a prior domestic arbitral award or judgment. So
Yes.
he's put the two together.
Yes.
When one goes to the judgment itself, at the in answer to the third question, paragraph 74 and following, they have adopted the Advocate General's reasons.
Where?
Practically word for word. Well, let's look at start at 77. Well, no, I suppose we go back to 74. Sorry. The third question, the referring court asks whether, in essence, 34.1 must be interpreted as meaning that in the event that 34.3 of that regulation doesn't apply to a judgment entered in the terms of an arbitral award, the recognition or enforcement of a judgment from another member state may be refused as being contrary to public policy on the ground that it would disregard the force of res judicata acquired by the judgment entered in the terms of the arbitral award.
Yes, in the terms of the arbitral award. It's a judgment entered in the terms of the
Yes, I see that.
Yeah.
In that regard, it follows that the answer to the first two questions, in the present case, the inapplicability of Article 34.3 of the regulation, which judgment referred to in paragraph 29 above, results from the fact that the arbitral proceedings which gave rise to the award confirmed by the judgment were completed in breach of the rules of res pendens and Article 27 of the regulation, relative effect of an arbitration clause included in the insurance contract. In those circumstances, it cannot be considered...
that's totally a diversion from the Advocate General. I mean, that's their answer, not his.
That's their answer derived from the qualification that they added to his in answer to questions 1 and 2.
I mean, just pointing it out.
No.
Because I think you're going to drag something out of the next two paragraphs, which may not.
In
be
any
there.
event, according to the case law of the court, 34.1 must be interpreted strictly as much as it constitutes an obstacle to the attainment of one of the fundamental objectives of the regulation. Pausing there, one of the objectives of the regulation is the almost automatic recognition of other member state judgments. automatic, anything that inhibits the automatic respect to member state judgments is something which is, on the face of it, offensive to the regulation. That's what they're saying.
But something which would inhibit automatic recognition would be a refusal to recognise by, let's say, a French court on the grounds that that the judgment was contrary to an enforceable New York Convention award. That would be as much a clog, wouldn't it, on enforcement as any other inhibition?
Except that it may be an issue to be debated after the recognition and entry of the Brussels regulation judgment. It may arise in relation to domestic enforcement within the enforcing state.
You mean you recognise the Brussels you recognise the EU judgment, and you've then got a conflict between that and an equally enforceable arbitral award.
And that would then be dependent upon whether, if the award neutralises the effect of the judgment, whether that would itself be a breach of the effectiveness principle. That raises, that would be, leaving aside Brexit,
No,
there
I see
would still,
conceptually
do you see the point?
Yes, I do.
But it arises at a later stage in the analysis.
So
than,
you're saying you can have a tension, if you like, not necessarily a conflict, a tension between a recognised judgment, which has got to have force throughout the EU, and an arbitral award, which also may have force throughout the EU.
via the New York Convention.
By a New York Convention, or domestically, because if it's a domestic award, it can't be enforced by the New York Convention. So it can only be enforced via recognition.
It can only be enforced ultimately by entering it as a judgment, and then you're back to where you started.
Exactly. And that's the conundrum. That's why sort of moving it into the next analysis doesn't really work with the domestic arbitration agreement. That's the problem. I can see how it might work for a foreign one.
Well,
it's recognised under the convention.
But the solution of the Court of Justice in that case is that the regulation judgment takes primacy, because it's got to be automatically enforced. But it does come at the, as it were, at the domestic enforcement stage, not the recognition stage. It's no answer to recognition under Article 34 to say, all right, the judgment can be recognised. Query how it's enforced is a matter of domestic law, whether there's a right of set-off or not, whether there are indeed equitable compensation rights which are equal and opposite. That's at a different stage in the inquiry, and that's not the stage of the inquiry with which you, my lord, my ladies, are
concerned.
Currently concerned
But the
with.
question you were answering, but seem no longer to be, is why the Court of Justice is to be taken as having included
Yes.
a res judicata or issue of stoppage relating to the award itself. And the
Well,
answer to that question, if I may pose it myself, since you got waylaid and it's 4:15, you can tell me if I'm wrong in the morning, is because he refers at paragraph 79 of the opinion of the Court of Justice to paragraph 77 of the Advocate General. And paragraph 77, although does talk about exhaustive regulation of the issue of res judicata and irreconcilability, and in paragraph 78 refers back to the prior domestic award. And so, although it's not clear, you say it was in fact endorsing that same approach.
I say it's impossible to read that as disagreeing with.
Yes, well,
Yeah,
I see the
General,
point. I mean, you know, by all means, return to it in the morning, but I just wanted the answer tonight.
That's the
So
point.
that I can sleep on it.
My lord, I will trim my notes amazingly overnight. If that's any consolation.
In my experience, it's not notes that matter, it's submissions.
I apologise for hijacking, Mr.
You
Young.
know, I said at the outset, I won't say hijacking, I welcome questions from the bench, and I still do.
Excellent. Thank you very much, Mr. Young.
Court rise.
10:30.